Hello and welcome to Triage, timely conversations for healthcare professionals, a podcast created and produced by K&L Gates. Each episode is designed to highlight important developments in health law and analyze the impact on our clients and friends of the firm. We hope you enjoy this podcast.
Hello, and thank you for listening to Triage. My name is Gabe Scott, and I'm an associate in the firm's Research Triangle Park, North Carolina office. I'm joined today by my colleague, Andy Ruskin, a partner in the firm's Washington, D.C. office. Today, we'll be talking about some recent developments in regard to community hospitals that don't want to be precluded from ever having Medicare reimbursement for residents. So, Andy, CMS recently issued a rulemaking that implements graduate medical education provisions in Section 131 of the Consolidated Appropriations Act, which is referred to under the acronym CAA. Andy, what does Section 131 of the CAA do?
Good question, Gabe. So it does a number of things, but relevant for purposes of this triage is it allows community hospitals to press the reset button, if you will, for two components of the direct graduate medical education component of Part A reimbursement. So direct versus as opposed to indirect medical education reimbursement is comprised of both the per resident amount as well as the full-time equivalent resident amount, which are both multiplied by the Medicare utilization percentage to come up with the direct graduate medical education component. Due to some interpretations by the agency regarding what it takes to set the per resident amount, which is what it sounds like, which is the amount per resident that a hospital is entitled to under the direct or DGME component of graduate medical education, there is a need to basically try to get it started from scratch, because in some cases CMS has said that the per resident amount is zero simply because a community hospital, unbeknownst to it, had actually had a resident on site as part of that resident's training. And oftentimes the community hospital was completely unaware that the resident was even on its premises, much less actually doing anything in the way of formal training on site. So some hospitals have had a per resident amount of zero, which basically means you get, zero times anything else is zero. And so as a result, some of these hospitals have been hit with this per resident amount of zero and have never been able to get DGME. In some cases, the amount of training that occurred on site that led to this was woefully little. I'm aware of one hospital that got hit with a per resident amount of zero after having 0.3 FTEs on site over the course of a particular year. So this was a policy that never really made any sense. And Congress basically stepped in and said that if you were engaged in de minimis training, you get to start all over again, so long as you engage in training within the next 5 years. Then at that point you get a fresh start. This also holds true for the FTE count component. Ever since 1996, hospitals have been subject to a cap on the number of residents they're allowed to train and get paid for. And so hospitals that did not have a cap in 1996 can start new programs. And when they start a new program, they're allowed to develop a new cap. Now, typically you have 5 years to ratchet up and get your full complement of residents before your FTE cap is established. But what some hospitals have found is that CMS is applying this rule that if you trained residents at all during the first 5 years, then you get an FTE cap, even if you had no intent to be participating long-term in any sort of training program and develop a cap. So this has created complexity as well, and Congress there too has said if you got stuck with an FTE cap, you get a fresh bite at that apple as long as you start your training within the next 5 years. So that's what Section 131 of the CAA does.
Great. Thanks, Andy. And so in terms of the types of hospitals that should be paying attention to this rulemaking, what do you recommend?
Yeah, so every hospital should be paying attention. That's a community hospital that does not have a per resident amount or an FTE cap that it's already happy with, or at least is unhappy with, but understands it can't do anything about. So if you're a community hospital and you have even a whiff of a belief that you had training on site at some point, now is your chance to try to get the record straight. We'll talk about it with process CMS has set up in a second, But essentially, it's incumbent on every community hospital at this point to do some due diligence on itself and figure out if it's ever had anyone at the hospital who's ever been aware of training that may have occurred on site by any of its volunteer medical staff who may have acted as a preceptor and brought a resident on site. You need to know that now, and you need to clear it. And even if you find out that there's never been a resident on your premises ever, which is hard to prove the negative, but if you do, then just understand that from this point forward, if you're ever on a rotation schedule for any other hospital ever, and you go above 1 FTE, you will now be permanently foreclosed from ever having the ability to establish a per resident amount that makes any sense. So every community hospital that thinks it should or believes it is what we'll call a virgin hospital, meaning completely naive to any sort of residency training, needs to confirm that fact now and protect its status for time immemorial.
Thanks, Andy. So as hospitals assess their historical engagement in this way, what does CMS now allow these hospitals to do?
Yeah, so pursuant to the statute we talked about a minute ago, CMS has said in its recent rulemaking from December 27th of last year that these hospitals are now allowed to go to their MAC before July 1 of this year and show them that they had fewer than 3 FTEs on site. And as a result of that, they had an FTE cap imposed upon them, then they get that removed. Or if they had a PRA, they get that removed, but only if they're going to start some form of training going forward within the next 5 years. So, i.e., they have to start that training before 2025. But once they do start that new training, the PRA and or the FTE cap, depending upon what they've been straddled with so far, will be superseded by the new PRA and or FTE cap.
Great. And so as hospitals, assess whether this applies to them, what sort of planning and timing do you anticipate is involved?
Yeah, so once you're done with the assessment as to where you are vis-a-vis any sort of involuntary imposition of a PRA or an FTE cap, the next step is to work with the medical school or the other hospital in the community that was responsible for the program and the residents. Try to get copies of the rotation schedules for as far back as you can go, and then make sure you're ready to submit everything by July 1. At the same time, you have to figure out a way to get at least 3 FTEs on site for developing a per resident amount using cost data that's going to be more appropriate for you. In other words, you have to pay for residents of at least 3 FTEs in order to be able to supersede the PRA, the presumed PRA of 0. And then you can have that per resident amount for your use for time immemorial. But you do have to pay for them so that you get to a number that's optimal. And so that involves some planning, as you have to find a hospital that will send you 3 FTEs and will allow you to pay them for those FTEs so that you get there. And if you have an FTE cap already, then you would actually have to start a new program, become either a program sponsor or otherwise become a major participating site in a program so that you can get a new FTE cap. There will be far more instances where the PRA is at issue than the FTE cap, and every hospital needs to figure out whether or not they're at risk that a PRA has been set.
Great. So, Andy, what does a hospital get, that follows the processes that you've outlined?
Yeah, so if you get a new per resident amount, that doesn't guarantee you reimbursement, but it does mean that if in the future you ever do start a medical residency training program or into something called the GME affiliation agreement, you'll get paid for your direct GME, which you will not if the MAC decides that you're entitled to a 0 PRA because you had some incidental training on site that you didn't even know about. So it's not a guarantee of reimbursement immediately. It's just a guarantee that you will have that as an option going forward. And essentially, given how many physicians we still need to be putting out into the world in order to deal with the physicians shortage, then basically every hospital at some point is going to be involved in some sort of training.
Right. And so as hospitals think about their planning associated with this, some hospitals may consider the complexity involved and the time that it may take to comply with these processes. What happens if hospitals do nothing?
Yeah, so after the 5 years is up and you decide to do nothing and the MAC ever finds any evidence that you have no idea about and it was not your intention but they find any evidence residents were on site and you get hit with a PRA of 0, then you will never be able to train residents and get paid for that ever again. And that's going to be a huge problem for a lot of hospitals, especially when they're sold. So if you're a community hospital part of a system and that system wants to sell that hospital and your PRA is 0 or could become 0 once the MAC starts looking at it, then that's absolutely going to affect the value of that hospital. That is becoming a question in due diligence because you will be forever foreclosed from getting paid the direct GME component of graduate medical education reimbursement once that happens. So, Gabe, thank you so much for asking these questions. I do hope that our listeners find this of value. It's a really important issue because you sleep on your rights here and there will be pretty significant consequences. So thank you very much. And thanks to all the listeners for allowing us to share this important development with you.
Thanks again for listening to Triage, timely conversations for healthcare professionals. New episodes are available for download through Apple Podcasts, Google Podcasts, and Spotify. By subscribing to Triage, you will receive timely notifications for each new episode. Also, if you have any topics you would like to hear discussed on Triage, please don't hesitate to email triagesupport@klgates.com. We would love to hear from you.